If you're a green card holder, visa holder, or any non-citizen living in the United States, there's a bill moving through Congress right now that could dramatically change your life. I'm talking about H.R. 875, and what it proposes is something that has immigration attorneys across the country raising serious concerns. A single DUI could become grounds for automatic deportation, even for people who've lived here legally for decades. But here's what you need to know. This is not yet law, and understanding the facts right now could protect your future. Stay with me because I'm going to break down exactly what's happening, what it means if this bill passes, and most importantly, what you can do to protect yourself and your family. Welcome to US Guide, where we bring you accurate, reliable information about immigration law and policy. My name is John, and on this channel, we cut through the confusion and give you the facts you need to make informed decisions about your immigration journey. Before we dive in, make sure you hit that subscribe button and turn on notifications so you never miss an important update. Immigration law changes constantly, and staying informed is one of the best ways to protect yourself. If this information helps you, please share it with friends or family members who might need to hear it. Now, let's talk about H.R. 875. What's really happening with this bill and what it could mean for immigrant communities across America? What is H.R. 875? The current status. Let me start with the most important fact. H.R. 875 is currently a bill pending in the United States Senate. It is not yet law. It has not been enacted. No one is being deported under this legislation today because it hasn't been signed into law yet. Here's what has actually happened. On June 26, 2025, the U.S. House of Representatives passed H.R. 875 by a vote of 246 to 160. The bill's official name is the Jeremy and Angel Say and Sergeant Brandon Mendoza Protect Our Communities from DUIs Act of 2025. It was introduced by Representative Barry Moore from Alabama. The very next day, on June 27, 2025, the bill was received by the Senate, where it was read twice and then referred to the Senate Judiciary Committee. That's where it sits right now. As of today, for H.R. 875 to become law, it must pass the Senate, which means it needs to get out of the Judiciary Committee, receive a full Senate vote, pass that vote, and then be signed by the President. Only after all of those steps would it become enforceable law. Now, the White House has publicly endorsed this bill, which signals executive support, and the fact that it passed the House with significant bipartisan support, 246 votes, suggests there is momentum behind it, but momentum doesn't mean certainty. Many bills pass the House and never make it through the Senate. According to legislative tracking data, only about 21% of bills that make it past committee actually become law. So when you see headlines or videos claiming this is already affecting people, that's not accurate. But what we can do is look at what this bill proposes and understand what would happen if it does become law. What would H.R. 875 do if enacted? If H.R. 875 becomes law, it would make fundamental changes to the Immigration and Nationality Act. Specifically, it would amend two key sections, Section 212, which deals with inadmissibility, and Section 237, which deals with deportability. Let me break this down in plain language. Inadmissibility provisions. The bill would create a new ground of inadmissibility under Section 212A2J. This means that any non-citizen who has been convicted of a DUI, who admits to committing a DUI, or who admits to acts that constitute the essential elements of a DUI offense would be considered inadmissible to the United States. What does inadmissible mean? It means the government could legally deny you entry into the United States. If you're a green card holder who travels abroad and tries to return, you could be stopped at the border and refused entry. Even more concerning, you could be deemed inadmissible while you're already living here, which means the government would have legal grounds to begin removal proceedings against you. This applies regardless of whether the DUI is classified as a misdemeanor or a felony under state, federal, tribal, or local law. The bill explicitly states this. So, even if your state treats a DUI as a minor misdemeanor, federal immigration law would treat it the same as any other DUI, deportability provisions. The bill would also add Section 237A 2G, which addresses deportability. Under this provision, any non-citizen who has been convicted of a DUI or DWI offense, whether involving alcohol or drugs, would become deportable. Again, it doesn't matter how your jurisdiction classifies the offense. A first-time misdemeanor, DUI, would be treated the same as a more serious offense for immigration purposes. Who would this affect? This would apply to all non-citizens, which includes green card holders, people on work visas, student visa holders, temporary protected status holders, and anyone else who is not a U.S. citizen. Even lawful permanent residents who have lived in America for 20, 30, or 40 years would be subject to these provisions. The admission problem. One of the most concerning aspects of this bill is the language about admissions. You don't need a formal conviction to trigger inadmissibility. Simply admitting to a police officer, a judge, or an immigration official that you consumed alcohol before driving could count as an admission. In some cases, even acknowledging that you understand what constitutes a DUI, such as operating a vehicle while impaired, could potentially be used against you in immigration proceedings. This is significantly different from how most people understand criminal law. In the criminal justice system, you have the right to remain silent, the right to an attorney, and various protections. But in immigration law, statements you make can have consequences even without a criminal conviction. How this differs from current law? It's important to understand that DUIs already carry immigration consequences under current law. However, the current system is more nuanced. Under existing law, a single simple DUI is generally not considered a crime involving moral turpitude, which is one of the main grounds for deportability. The U.S. Supreme Court ruled in a case called Leol versus Ashcraftoft that a DUI causing injury, which could be committed with mere negligence, did not qualify as a crime of violence for immigration removal purposes. The Board of Immigration Appeals has also said that a simple DUI by itself is typically not a crime involving moral turpitude. However, current law does allow for deportation in cases involving aggravating factors. Multiple DUIs, a DUI combined with driving without a license, DUIs causing serious injury, or DUIs involving other criminal conduct can create deportability concerns. The system currently weighs the seriousness of the offense, the circumstances, whether there was rehabilitation, and other factors. What H.R. 875 would do is eliminate that discretion. It would make any single DUI, even a first offense with no aggravating factors, an automatic ground for both inadmissibility and deportation. There would be no room for judges to consider rehabilitation, time passed since the offense, family ties to the United States, or other mitigating circumstances. The bill as currently written does not include any discretionary waiver provisions. This represents what legal experts call a zero-tolerance approach. One mistake, one conviction, one admission, and you could lose your legal status in the United States permanently. Real-world implications. Let me paint a picture of what this could mean in real life. Imagine someone who came to the United States as a child, grew up here, went to school here, started a family here, bought a home, and has been a green card holder for 30 years. They've paid taxes, contributed to their community, never been in serious trouble. But one night, they make a terrible mistake. They have 2 drinks at dinner, believe they're okay to drive, get pulled over, and are charged with DUI. Under current law, while serious, this might not automatically lead to deportation, especially if it's a first offense. Under H.R. 875, that person would become immediately deportable. Their entire life in America could be erased. Or consider a student on an F1 visa who admitted at a party 2 years ago that they once drove after having a couple of beers. They were never arrested, never charged, but they made that statement. If they later apply for a green card or try to adjust their status, and that admission comes up somehow during immigration proceedings, they could be denied and removed from the country. What about green card holders who travel internationally for work or to visit family under H.R. 875? If you have any DUI on your record, leaving the country could mean you're not allowed back in. You could be denied re-entry at the border, separated from your spouse, your children, your job, everything you've built. Immigration attorneys are particularly concerned about the retroactive implications. The bill does not include language that would limit it to future DUIs only. This means that people with old DUI convictions, even from 10 or 20 years ago, could potentially be affected when they interact with immigration authorities for any reason, whether they're renewing a visa, applying for naturalization, or traveling internationally. The bill also doesn't distinguish between alcohol and drug-related impairment. Both would be treated identically under the law. Why this bill exists? The arguments. To understand this issue fully, we need to look at why supporters believe this legislation is necessary. Proponents of H.R. 875 argue that it closes what they see as a loophole in immigration law. They point to tragic cases where individuals who were not U.S. citizens drove under the influence and caused accidents that killed or seriously injured people. The bill is named after victims Jeremy and Angel Assia, a married couple from Enterprise, Alabama, and Sergeant Brandon Mendoza, an Arizona law enforcement officer. These were real people whose lives were cut short in accidents involving impaired drivers who were not citizens. Supporters argue that public safety must be the priority. They believe that if you're a guest in the United States, whether as a visitor or even as a lawful permanent resident, you should face serious consequences for endangering others through impaired driving. They see deportation as both a punishment and a deterrent, something that will discourage dangerous behavior and hold non-citizens to high standards of conduct. Representative Barry Moore, the bill's sponsor, has stated that this is common sense legislation and that it should receive bipartisan support because deporting dangerous criminals is rational and normal. The opposition's concerns. However, the bill has significant opposition from immigration attorneys, civil rights organizations, and advocacy groups who believe it goes too far. Critics argue that H.R. 875 treats a low-level misdemeanor as if it were an aggravated felony. They point out that DUI offenses, while serious, exist on a spectrum. Someone who drives with a blood alcohol content slightly above the legal limit without causing harm is fundamentally different from someone who causes a fatal accident. Yet this bill would treat them identically for immigration purposes. Opponents also emphasize the lack of discretionary relief. Immigration law has traditionally allowed judges to weigh factors like rehabilitation, family ties, length of residence, and positive contributions to the community. H.R. 875 would eliminate that human element entirely. Someone who made one mistake decades ago has since completed treatment, has lived a model life, and has American citizen children would receive the same treatment as a repeat offender. Civil rights advocates have raised concerns about how this law could interact with discriminatory policing practices. Studies have documented that traffic stops and sobriety checkpoints are often concentrated in immigrant communities and communities of color. If the mere act of being stopped at a checkpoint and admitting to past alcohol consumption can trigger deportation, this creates enormous potential for abuse and selective enforcement. There's also the constitutional question. Legal scholars have raised concerns about due process and whether it's proportional to permanently banish someone from the country they've called home for years, sometimes decades, based on a single misdemeanor offense. What you need to do right now. Now, let's talk about what matters most. Protecting yourself and your family. For non-citizens currently in the United States, first and most important. Second, be extremely careful about any statements you make to law enforcement, immigration officials, or anyone in an official capacity. You have the right to remain silent. You have the right to an attorney. If you're ever in a situation where you're being questioned about alcohol or drug use, especially in connection with driving, do not make casual admissions. Politely decline to answer and request to speak with an attorney. Third, if you have a DUI on your record from the past, now is the time to consult with a qualified immigration attorney. Get a professional assessment of how this bill, if it becomes law, could affect your specific situation. An attorney can review your case, examine the details of your conviction or admission, and help you understand your options. They may be able to identify defenses or strategies to protect you. Fourth, Be very cautious about international travel right now. If you have any DUI history and you're a green card holder, leaving the United States could be risky, especially if this bill passes while you're abroad. You might not be allowed back in. If you must travel, consult with an immigration attorney first. For green card holders, if you are a lawful permanent resident and you've been delaying your naturalization application, now is the time to seriously consider moving forward. This is not about fear-mongering. This is about reality. Citizenship is the only true protection from deportation. As a U.S. citizen, you cannot be deported for a DUI or virtually any other offense short of the most serious crimes. Your right to remain in the United States becomes permanent and protected by the Constitution. The naturalization process takes time. It requires preparation, documentation, sometimes legal assistance, and there are costs involved, but the protection it offers is invaluable. Start the process now while you still have the opportunity. For people facing current DUI charges, if you are a non-citizen and you're currently facing DUI charges, you need both a criminal defense attorney and an immigration attorney working together on your case. Many criminal defense lawyers don't fully understand immigration law. They might negotiate a plea deal that seems favorable from a criminal perspective, but creates immigration consequences you don't realize until later. Your defense attorney needs to coordinate with immigration counsel to ensure that any plea agreement, any admission, any factual stipulation doesn't inadvertently create deportability or inadmissibility exposure. Don't assume your criminal lawyer understands immigration law. Ask the question explicitly. Get professional help. I cannot stress this enough. Do not rely on advice from friends, family members, or social media unless they are qualified immigration attorneys. Immigration law is incredibly complex, and the stakes are too high for guessing or assumptions. A mistake in how you respond to a question, how you fill out a form, or how you handle an interaction with authorities could determine whether you stay in America or lose everything. If you cannot afford an attorney, look for legal aid organizations, pro bono services, or nonprofit immigration clinics in your area. Many organizations provide free or low-cost consultations to help you understand your situation. The bigger picture, it's important to step back and understand what H.R. 875 represents in the broader context of immigration policy. This bill is part of a trend toward what's called crimmigration, the increasing intersection between criminal law and immigration enforcement. Over the past several decades, the grounds for deportation have steadily expanded. More and more offenses, some quite minor, have become triggers for removal proceedings. Proponents argue this protects public safety and holds non-citizens accountable. Opponents argue it creates a two-tier justice system where citizens and non-citizens face vastly different consequences for identical behavior, and where people who've built their entire lives in America can be exiled for single mistakes. The political dynamics are also worth noting. H.R. 875 passed the House with support from both Republicans and Democrats. This bipartisan backing suggests there's genuine legislative momentum, though it's not unanimous. The Senate Judiciary Committee will now hold hearings, debate the bill, potentially amend it, and decide whether to send it to the full Senate for a vote. Immigration advocates are lobbying senators to oppose the bill, amend it to include discretionary waivers, or add protections for long-term residents. Supporters are pushing for swift passage. What happens next depends on political considerations, public pressure, and whether senators believe the bill strikes the right balance between public safety and fairness. Staying informed. Because this situation is still developing, it's crucial to stay informed about what's happening with H.R. 875. You can track the bill's progress on congress.gov by searching for H.R. 875. This will show you any committee hearings, amendments, votes, or other actions taken by the Senate. Follow reliable immigration law sources. Organizations like the American Immigration Lawyers Association, immigrant rights advocacy groups, and reputable immigration law firms often publish updates and analyses when legislation moves forward. And of course, stay subscribed to this channel. As soon as there are significant developments with HR 875 or any other immigration legislation, we'll bring you the information you need, clearly explained and fact-based. Let me wrap this up with the most important takeaways. CH 875 is not currently law. It's a bill pending in the Senate, but if it passes and is signed by the president, it would represent one of the most significant expansions of deportation grounds in modern history. A single DUI would become grounds for automatic deportation and inadmissibility for all non-citizens, including green card holders. The consequences would be severe, permanent, and would affect millions of people. There would be no discretion, no consideration of mitigating factors, no second chances for people who've rehabilitated or built their lives here. What you need to do is simple. Don't drive impaired ever. Be careful about statements you make to officials. If you have a DUI history, consult an immigration attorney. If you're a green card holder, seriously consider pursuing citizenship and stay informed about this bill's progress. This is not about creating panic. This is about empowering you with accurate information so you can make informed decisions and protect your future. If this video helped you understand HR 875, please give it a thumbs up and share it with anyone who needs this information. Immigration affects real people, real families, real lives. The more people who understand what's happening, the better equipped they are to navigate it. Leave a comment below telling me where you're watching from and whether this bill concerns you. I read every comment, and your input helps me create content that serves this community. Remember, knowledge is protection. By understanding these laws and taking appropriate steps, you give yourself the best chance to build the secure future you're working toward. Thank you for watching US Guide. Until next time, stay informed, stay safe, and take care of each